Hello.
Hello.
So, are you able to hear me?
Are you able to hear me?
Okay, so let's start the class. Okay, so let us start from contract of agency. Okay, so today we'll discuss about contract of agency. We'll start from contract of agency. So, what is a contract of agency? So, let us see. The legal terms master servant and employer employee are used interchangeably over time. Okay, so actually, employers usually delegate a broader range of responsibility to their employees. You know, for example, by giving them authority to contract for raw material, or in case if they want to sell finished products, employers usually delegate these authorities and responsibility to their employees. Okay, even to employ other employees also. So sometimes they delegate the authority to employ other employees also. In these expanded roles, the employees became an agent. Okay, and uh, their employers were called principals. Okay, the employees are called agents and the employer is called the principal. Okay, the Indian Contract Act 1872 makes provisions as regards agencies. Okay, regarding the agencies, section 182 to 238 deals with the subject of agency. Okay, it includes definitions, rights and duties of the agent and principal, authorities of the agent, and termination of the agency. So these kind of things are covered in uh, section 182 to 238. Okay, so um, so what is the definition? Section 182 of the Contract Acts, which defines the words agent. And principle as follows. An agent is a person employed to do any act for another or to represent another in dealings with third person. An agent is a person who represents another person in dealing with third parties. Okay, here the person will not be directly dealing with the third parties, but he'll be uh, through an agent, or the principal will be dealing. Okay, and essential features of agency are that principal must be competent competent to contract in a sense. He should be above the age of 18, and other various aspects um, like he has to have a attain the age of majority, and may employ an agent according to section 11 of the act. Every person is competent to contract who is of the age of majority, okay, and also of the sound mind, and is not disqualified from contracting by any law of which he is subjected to. Okay, so thus principal should be competent to contract. Okay, when he is competent to contract, uh, he can use the services of the agent. Okay, any person may become an agent. Here, any person can become an agent, but uh, actually, Anson has described, in a sense, full contractual capacity is not necessary to enable persons to represent another as agent. Okay, there is no need to have a full contractual capacities. Okay, and even an infant can become an agent, and also this though a minor cannot employ an agent, yet he may become an agent. With the case of minor, he cannot employ an agent, but he can become an agent, but he will not be having any liabilities. In a sense, he will not be responsible for his to his principal. Okay, and also um, no consideration is necessary for the creation of an agency. Okay, there is not necessary. Actually, this is in section 185 provides no consideration is necessary to create an agency. This is yet another exception to the general rule enshrined in section 25, where we learn that agreements without consideration is void. But this is a case of exception, that here consideration is not necessary. Okay, and also let's focus on the classification of agents, how the agents have been classified. Like there are general agents, special agents, and universal agents. General agents are the ones who are employed to do all acts connected to a particular business or employment, where he can bind the principal by doing anything. Okay, his principal will be binded by the acts performed by the agent. Okay, and which falls within the ordinary scope of the business. Whether he is actually authorized for any particular act or not is immaterial, provided that the third party has acted bona fide. Okay, if a third party has acted, bona fide, the principal will be held responsible for the actions of the agent. Okay, that's the general agent. And special agents. Special agents are the agents employed to do some particular acts, or represent his principal in some particular transactions. Example, if an agent employed to sell a motor car, as soon as the performance is done, the contract will be over. I mean, in a sense, the authority of such an agent comes to an end. Okay, it will be ending. So in the same way, universal agent is said to be one uh, whose authority is unlimited. Here, universal agent has unlimited authority, and who is authorized to do all the acts which the principal can lawfully do and can delegate. All the acts which the principal can lawfully do and delegate, those are uh, with the universal agent. Okay, and another classification from the point of view of the nature of work performed by them is mercantile agent, factor, commission agent, creditor agent, and broker. Okay, these are another classifications of agents, whereas a mercantile agent, who has authority either to sell goods or to buy goods, or to raise money on the security of goods. Okay, here mercantile agent is actually a person who is authorized to sell goods and also to buy goods, and he can also raise money on the security of goods. Okay, that's section 2A of the Sales of Goods Act. As per section 2A of the Sales of Goods Act. Okay, the various kinds of mercantile agents are like factor. Factor is a mercantile agent whose goods are entrusted, with whom the goods are entrusted for sale. He enjoys wide discretionary powers in relation to the sale of goods. He sells the goods in his own name upon such terms as he thinks best, and he may pledge the goods also. Okay, he can also pledge the goods. The Okay, he'll be interested with the sales. And also commission agent. A commission agent, his main intention is to, he performs the principal's duty on the best possible terms in his own name. Okay, and he is also able to pledge the goods as well. Okay, whereas in del creditor agent is a person who is considered of an extra commission. Okay, he is in the consideration for an extra commission. Okay, because he guarantees, in a sense, when the principal is dealing with the third party, uh, if the buyer does not pay, thus he occupies the position of a surety as well as an agent. Okay, that's del creditor agent. He works as a surety also in case the buyer fails to pay. Okay, and also next one is broker. Broker, in a sense, one who's employed to make contract for the purchase and sale of goods. Okay, he is not interested with the possession of goods. Here the goods will not be interested with the broker, but he simply acts as a connecting link and brings the two parties together and bargain. And if the transaction materializes, he becomes entitled to his commission called brokerage. Okay, so that's with the broker. And non-mercantile agents, they include advocates, attorneys, insurance agents, wife. They can be as agents. Okay, they can represent uh, as agent, and they are non-mercantile agents. Okay, next one is a creation of agency. How an agency will be created? Let's focus on that. Um, an act done by an agent on behalf of the principal binds the principal towards a third party or third person. Okay, an act done by an agent on behalf of the principal binds the principal towards a third person, as I already told you before. And principal's liability towards the third person arises. Okay, in this way, the principal is bound by the acts of the agent. An agency may be created in any one of the following ways. Okay, agency by express agreement, and agency by implied agreement. Express agreement, in a sense, I have already told you that with the word of mouth, or expressed through written or oral, and implied, in a sense, by act of doing, performing. Okay, earlier I have told you about these things in my previous classes also. Normally agency is created by an express agreement, specifically the scope of the authority of agent. However, in certain cases, to execute a deed, for example, if to execute a deed, a sale of purchase of land, the agent must be appointed by executing a formal power of attorney or on a stamp paper. Okay, in case of executing a deed or purchase of land and all, there I mean, it cannot be just expressed, but it should also be uh, in the form of formal power of attorney, or in the on the stamp paper. Okay, and agency by implied agreement. um, so there are circumstances of the cases that uh, some implied, in a sense, I already told you about that. Conducted of the parties on a particular occasion, or some form of relationship between parties. There may not be expressed, but during some situation, that some circumstances which comes where one person represents another person, and they'll be legally binding and responsible for their each other's actions. Okay, and that is by agency by estoppel, and agency by holding, agency by necessity. Agency by estoppel, in a sense, such an agency is based on the doctrine of estoppel, which may briefly be stated that where a person by his words or conduct has willfully led another to believe that certain set of circumstances or facts exist, where the person will be willfully led another person to believe. Okay, one person will be letting another person believe that certain set of circumstances or facts exist, and that other person has acted on that belief. Okay, he stopped or precluded for denying the truth of such statements, although such a state of things did not in fact exist. Okay, in this case, and also where he has in the agency by estoppel, he has led another person to believe that the agent is acting on the directions of the principal, and agency by holding out. Next one is where such an agency is based on the doctrine of holding out, whereas in case uh, alleged principal is bound by the acts of the supposed agent. If he has induced third person to believe that they are done with his authority. For example, agency by holding out requires some affirmation. In case if he is holding out, he has to affirm that he is not uh, associated with the agent. In case he has not, in that case, I mean, affirmative positive acts are conducted by the principal to establish agency subsequently. If there are any subsequent acts, for example, I'll give you an example where the employer has been accustomed to pay for goods. In some cases, principal, the owner, will be sending his agent to deal with, dealing with money with the third party, whether collecting the goods or paying money. Or in some cases, if the employer has already left the job and he has taken the money from the third party and or the goods from the third party, but the third party has acted in the belief that this agent is still representing the principal, still representing the owner, whereas he has already left the job. In this case, uh, this it will happen. Okay, so agency by holding out, in a sense, in case the owner has not communicated this, that the employee is no longer working for him, it will become an issue and he'll be held liable by the third party. Owner will be held liable for by the third party. Okay, next one is agency by necessity. Okay, in these circumstances, the law confers an authority on one person to act as an agent for another without any regards. In this case, the law will be placing a person to represent as an agent. Okay, in special circumstances, law will do this. Okay, without the consent of the principal also, it's a mandatory that he has to be bind by the acts of his principal, is his agent. Okay, such an agency is called agency of necessity. Okay, there should be a uh, when it will happen, in a sense, there should be a real necessity for acting on behalf of the principal, or there should be impossible to communicate with the principal within the same time. Okay, and also when alleged agent should act, the alleged agent should act bona fide in the interest of the principal. Okay, in these cases, the law will uh, entrust the responsibility of the agency. In a sense, it will be making the agent, uh, and the agent has to should act bona fide. Okay, and next one is agency by ratification. Agency by ratification, in a sense, where a principal affirms or adapts the unauthorized act of his agent. In a sense, sometimes uh, agent will be acting something certain dealings. He may enter into contract with a third party, representing the principal without the knowledge of the principal, where a principal has not given the consent. But after coming to know, if the principal is still, if he doesn't take action against that, it will be affirmed that the author he has authorized the agent. Okay, for example, I'll give you an example where A buys 5 bags of wheat on behalf of B. Okay, B did not appoint A as his agent. Okay, here A buys 5 bags of wheat on behalf of B, but B has not appointed A, okay, on his as his agent. But B may, upon hearing of the transaction, accept or reject it. Here B have the choice, after hearing of the transaction, he can accept or reject. Okay, if B accepts it, the act is ratified and A becomes his agent. Okay, retrospectively. Um, okay, that's how it works. Next one is extent of agent's authority. As we don't have a lot of time, I'll not be going too much in the detail because it will consume. I mean, it will take a lot of time. So I'll just try to brief as much as possible, so you can all get a brief idea about the whole subject. Okay, and please refer our SLMs what we have given, self-learning material and also the reference books for in-depth knowledge. Here I'll just brief as much as I can for your understanding. Okay, next one is extent of agent's authority. So here, uh, what extent to an agent is authorized, we'll focus on that next. Okay, so first one is actual authority. Okay, actual authority in a sense, an agent can do all such acts as have been assigned to him, either expressly or impliedly, and thereby bind the principal to third parties by act done within the scope of his actual or real authority. Okay, that is actual authority. He is binding his principal to all such acts as have been assigned to him, either expressly or impliedly, okay, by the principal. And next one is uh, ostensible or apparent authority, whereas the act is in excess of his actual authority, whereas the agent will be doing more than what he is authorized to do. And in that case, third party may have not knowing that what is the limitations of the agent. Okay, in this case, it's ostensible or apparent authority. So where he has acted more than what he is supposed to act, but still he'll be binding his principle with the third party on this transaction or on this dealing. Okay, next one is authority in emergency. Okay, authority in emergency in a sense, in case of emergency, the agent will do all such acts for the purpose of protecting his principal for loss, as would be done when he whatever he could do personally, in a sense, done by a person of ordinary prudence in his own case under similar some circumstances. If he could have done it in his own case, the same he'll be doing to the principal, that in the case of emergency, in order to save the principal from loss, incurring loss. Okay, that's authority in emergencies. Okay, next one is delegation of authority. Section 190 provides that an agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally. Here, uh, delegation of authority in the sense where the agent cannot lawfully employ another person, where he has expressly or impliedly undertaken to perform personally. Okay, the for whatever he has to do personally, he cannot appoint another person. Okay, unless by the ordinary custom of trade, a sub agent may, or from the nature of the agency, a sub agent must be employed. In case if there is a real necessity to employ a sub-agent. In that case, he can employ that too. He has to bring it to the notice of his principal, his owner. Okay, so sub-agents are, according to section 191, this a person employed by an agent is called a sub-agent. Okay, in case of due to some circumstances required in the business environment, he'll appoint another agent under him. So he'll be uh, reporting to the first agent. Okay, in the agent, sub-agent will be reporting to the agent, whereas substituted agent, in a sense, instead of one agent using another one agent. Okay, in case if the immediate agent, if he wants to go on a leave, or maybe in some such circumstances, if in case if he want to is going on a vacation or a holiday, in a sense, in that cases, there could be a substitute agent will be appointed instead of him. Okay. Um, okay. Next one is mutual relations. Mutual relations in a sense where will focus on the duties and rights of the agents and the principals. Okay. How mutually their relationship works, and what are the legal aspects, legal matters which will be binding them, and all those things will focus. Okay, so let's see what are the duties of an agent. To conduct a business of agency. Okay. um, to conduct the business of agency according to the principal's direction. Okay, that is the main duty of an agent according to section uh, 211, 211. They have to carry according to the directions of the principal, and their skills and diligence that is generally possessed by persons engaged in the similar business, and also to render proper accounts, and they should communicate with the principal in case of difficulty, and they should not make any secret profits. Okay, they should not make any secret profits, and not to deal on his in his own account. I know what the principal account, if he is supposed to deal in the principal account, he cannot deal it with his own account, and not entitled to remuneration for misconduct. There will not be any remuneration if he does any act against. Okay. So right of an agent. Next one is rights of an agent. So he'll be right to remuneration, and right to retain, right to lien, and right of stoppage in transit. The goods which is in transit, he has the right to stop that also, and right of indemnification, in a sense protection against loss. Here in case the agent has incurred the money out of his own pocket, and the principal's responsibility is to indemnify, in a sense protect him against the loss, and the right to compensation for injury caused by principal's neglect. In case if the principal has neglected, like made him work excessively, or any other sort of injuries caused due to the negligence of the principal, uh, agent can is liable to uh, for compensation. Okay. Right of an agent, also these things will be covered under it. And next one is rights and duties of the principal towards agent. In the same way, there are certain rights and duties of the principal also towards the agents. Okay. For example, to recover damages, the if there is any damages caused by the agent, the principal can recover for damages, and to obtain an account of secret profit. In case if the agent has maintained any secret profit, the owner or principal is uh, entitled to obtain the accounts. Okay, of the secret profits, and to resist agency claim for indemnity against liability incurred. Okay, in case if the agent has incurred any uh, a liability, he can resist against the claims by the agent. Okay, these are some of the rights and duties of the principal is indemnify the agent against the consequences, and indemnify the agent against the consequences of all lawful acts done in good faith. Okay, these are the duties. He should respect the agent, and whatever act he has done lawfully and in good faith, he has to indemnify. Okay, indemnify agent for injury caused by principal's neglect, and to pay the agent the commission or other remuneration agreed. Okay, these are some of the rights and duties of the principal towards agent. Okay, so the termination of agency. Uh, so next one is termination of agency, where the termination will be on revocation by the principal. The principal can revoke the agency with his will, and also on the expiry of fixed period of time. If the fixed period of time for which the agency has been established, if that time is elapsed, then it comes to an end. And on the performance of the specific purpose, if the if it is formed for performing some specific purpose, if it ends again, it will be coming to an end. Okay, insanity or death of the principal or agent, in both the cases, it will come to an end. Agency will be terminated, either the death or insanity of any one of the parties. Okay, and next one is insolvency of the principal. In case principal become insolvent, the agency will coming to an end. And by renunciation of agency by the agent. Here, the when the principal can terminate the agency, even the uh, agent can also terminate the agency by renunciation. Okay, he can but he has to give a due notice first. Okay, sufficient notice he has to give when if he wants to terminate the agency. Okay, without sufficient cause, if he try to terminates or renunciation, I mean rejects to perform his duties, the principal must be compensated. Here the principal is able to get the compensation from the agent. Okay, so that's with the uh, contract of agency. So let's move on to the next block, where I will discuss about Sales of Goods Act 1930. Okay, the Sales of Goods Act 1930. The act covers topics such as the concept of sale of goods, warranties and conditions arising out of sale, delivery of goods and passing of property, and other obligations of the buyer and the seller. Okay, here this act covers Sale of Goods Act 1930 covers the topics such as sales of goods, warranties and condition arising out of sale, and delivery of goods, passing of property, and other obligations of buyers and sellers. Okay, it also covers the field of documents of title of goods and the transfer of ownership on the basis of such documents. So, title of goods, what is the title? We'll discuss in um, I'll explain to you in short while, okay? And let us see the definition and essentials of sale. Okay, okay. So there must be at least two parties. Okay, one is seller and another one is buyer, as I told you earlier. So there must be at least two parties and transfer or agreement to transfer the ownership of goods. There should be transfer or agreement to transfer the ownership of goods. Okay, the subject matter of the contract must necessarily be goods. Okay, here the subject matter should only be necessarily be goods. Okay, goods and not immovable property. I mean building or those kind of things will come under immovable property. But here it will only focus on movable property. For example, like vehicles. All these things are movable property. And for example, okay, so the subject matter should be uh, necessarily be goods here. Okay, and money consideration, there should be consideration of money. Okay, consideration for a sale of goods must be money. And sale and contract for work and material. Here the sale and contract for work and material should be distinguished from a contract involving the exercise of skills or labor. Okay, contract of sale should be distinguished between contract involving exercise of skill or labor. Okay, on some material. Okay, so next one is goods. So what is goods? Goods means every kind of movable property. Okay, as I told you about, goods means every kind of movable property, including stock and shares, growing crops, grass, etc. Are movable property which are included. Okay, whereas money and auctionable claim are excluded from the definition of goods. Money and auctionable claim are excluded. They are not considered in the goods. Whereas like antique coins or currency notes, like collectors, what they use that when they auction will be going on for that. In that case, I mean that will also be considered as goods where uh, uh, where they become object of curiosity and maybe sold as goods. Okay, and next one is sale and agreement to sell. Okay, so what is a sale? A sale is an executed contract, whereas agreement to sell is an executory contract. Okay, uh, so what are the conditions and warranties? So let's see what are the conditions and warranties. What is a condition and warranty? So actually, usually. Uh, Every contract of sale is likely to contain a number of terms and conditions about the nature and quality of the goods. Okay, there will be maybe a number of terms and conditions about the nature and quality of the goods and their fitness for the buyer's purpose. Whereas non-fulfillment may seems to upset the very basic of the contract. If the goods doesn't fulfill what it is supposed to do, in terms of quality or fitness or the purpose for what the buyers buy the product, if it doesn't meet the required standards, it will be, you know it will upset the very basis of the contract. Okay, so it is so vital that their breach may seems to be a breach of the contract as a whole. Okay, breach entitles the innocent party to repudiate the contract, whereas repudiate in a sense, he may reject the innocent party can reject the uh, goods. Okay, and something which is not so much vitally important is known as warranty, and it does not lead to repudiation but only to damages for breach. Okay, warranty is where the only for the damages will be claimed, but not supposed to return and replace the entire product. Okay, the same thing will explain again. The condition is a uh, the conditions is a stipulated essential to the main purpose of the contract, the breach of which gives rise to right to treat the contract as repudiate, where the product can be rejected and replaced. Whereas the warranty is a stipulated collateral to the main purpose of the contract, the breach of which gives rise to the claim for damage, but not a right to reject the goods. Okay, and treat the contract as repudiate, not the right to reject and repudiate. It's called warranty, whereas we can have the right to repudiate, in a sense reject, it's called uh, conditions. And so let's see what implied conditions are. Okay, uh, express conditions and warranties is open to the parties, in a sense there will be uh, parties making they can express as many conditions and warranties as they can. Okay, they are open to any number of expressions. Okay, so they can put as much as they want, but the law implies into every sale of goods a number of conditions and warranties. Here the law implies a number of goods and number of conditions and warranties. The basic principle here is that in a sense the law implies these conditions and warranties because in order to protect the innocent consumers, the innocent party, whether he may be buyer or seller, uh, in order to protect the innocent party, law implies certain conditions. Okay, so conditions as to a title. So what is a title? Okay, the title actually is section 14 provides that in a contract of sale, unless the circumstances of the contract are such as to show a different intention, there is an implied condition, okay, on the part of the seller, that in the case of sales, he has a right to sell the goods, and that in the case of an agreement, he will have a right to sell the goods. at the time of the ownership. In a sense, for example, um, for suppose if the there is also a description where they say that the title can be best explained by the possessor. Whoever possesses the goods, he'll be in a position to best express the title. For example, if you are going to buy a vehicle, I mean the seller over there, they are the best, they can give a best description of the what the title is, okay, what the title of the product is. And in the same way, if you own a product, you will be able to give a best description. If you are the owner, you are the creator, you will be able to give a best description of the uh, product, okay, a best title. That is title here. And um, okay, so for example, if you buy it from, a stolen goods, if somebody, if some stolen goods are being sold, and one person, if a buyer will not get a good title on that, okay, if he purchase from the stolen purchase stolen goods or anything, okay. So let's move on. So next one is sales by description. Okay, there will be certain descriptions, implied condition that the good shall correspond with the description. Okay, whatever description has given, it should match that is another condition laid by the law. And sale by description as well as by sample, in certain cases the sample cannot represent the entire bulk, but the description, at least the description has to match. In case if both the description and sample does not match the entire bulk, the another party may be uh, in a position to reject. Okay, and exceptions to the rule of caveat emptor, let the buyer beware. There is a rule called caveat emptor. It's it means that let the buyers beware. It's the rule owes its origin in to the times when nearly all sales took place in the open market. Earlier, when there is no internet marketing, earlier people used to, buy and sell in the online market. I mean, in a sense, without the presence of the online market, they used to, I think we have another 10 minutes, so I'll try to cover as much as possible for today. Okay, so earlier there was all sales used to take place in an open market, but now the circumstances are different. Where earlier people used to go and touch and feel the products before buying, and they used to bargain with the buyers, but they used to see the product themselves and feel the product, then they used to buy. But nowadays, in the but as trade grew and assumed global dimension, now the sales is going on in global dimension, where online sales, where we cannot touch and feel the product, but we can only see or get some description about that. In that case, it's necessary to restrict the rule of KV tempter by grafting a few exceptions upon its scope. Okay, so law has some exceptions here uh, in order to restrict the rule. Okay, so fitness for the buyer's purpose. Section 16 provides for the following exceptions, where it provides fitness for buyer's purpose for whatever the purpose it is being bought by the buyer. It has to match that purpose. Okay, supplied goods which shall be fit for the buyer's purpose. Okay. um, for this condition to arise, the following points to be provided approved. Sometimes the buyer should make known to the seller the particular purpose for which the goods are required. Okay, buyer should make known to the seller the particular purpose for which it is used, and goods must be of a description which is the course of the seller business to supply, and it should be the seller's business to supply. Okay, that is with the fitness for buyer's purpose. And next one is it should be of merchantable quality. I mean, it should meet the quality as per its description. Okay, that's the basic thing. that it should be meeting the required quality standards. Okay, and next one is conditions implied by trade usage. An implied warranty or condition as to quality or fitness for a particular purpose may be annexed by the usage of trade. Next one is express terms. It is left to the parties to include any express conditions and warranties in their contract. But an express warranty or condition does not negative a warranty or condition implied by the act unless the express terms are inconsistent with the implied condition. Okay, so it doesn't have to contradict with the what the rules or what the law says. Okay, they can, otherwise they can include whatever as much expressed conditions and warranties as they want. Okay, next one is sale by sample. As I already told you about, sample sometimes it has to match. Okay, only to enable the buyers to form a reasonable judgment for the goods. Okay, sometimes just to make the uh, judgment related to the goods, it will be supplied by the uh, seller. Okay, the bulk shall correspond with the sample in quality. As I already told you, the bulk should correspond with the sample in quality. The buyer shall have a reasonable opportunity of comparing the bulk with the sample, and goods shall be free from any defects, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. In a sense, usually sometimes some things doesn't appear that easily. So this is an example of that. Okay, next one is implied warranty. So these are with the conditions for implied conditions. Next one is with the implied warranty. Okay, so with the quiet possession. Okay, so the quiet possession, in a sense, the possessor, in a sense, the buyer has to enjoy the goods, without the disturbance of the seller or any other person claiming to be the owner of the goods. You know, the purchaser, in a sense, the person who bought the item, he should have a quiet possession without any disturbance of the seller or any other party claiming that product is not accidentally have come to the buyer. Okay, so that is quiet possession. And warranty as to non-existence of uh, encumbrance. In a sense, there will be nobody else, any third party not declared or known to the buyer before or at the time of the contract is entered into. Okay, there must not be any third party. Goods shall be free from any charge or encumbrance in favor of any third party. Okay, and next one is disclosure of dangerous nature of goods. I mean, it's a basic necessity that all the dangers associated. For example, you may have seen, in the batteries, phone batteries and all. There'll be cleared descriptions that not to. It's related to e-wastes and all. It should not be disposed. There are there are certain ways to dispose it. Okay, these kind of things, and also the dangers associated with the goods should be disclosed clearly. And warranty, next one is warranty as to quality or fitness by uh, usage of trade. Okay, as I already told you that quality and fitness are uh, very important aspects. And let's see, next one is passing of property. Let's see, passing of property. uh, Okay, the significance of passing of property is, one of the most important effects is that risk prima facie passes with the property, that the goods are at the risk of the party to whom property has passed. He can exercise proprietary rights over the goods, but the risk is also associated with the ownership. You know, uh, ownership is also associated with the risk, whether it is with the goods is with the seller or with the buyer, whoever possesses the goods, the risk is with him. Okay. Okay, the next one is Sales of Goods Act 1930 Part 2. So I think we have very short time. I'll try to brief it as much as possible. So the law of this is just a continuation of the Sale of Goods Act 1930, where previously I have told you about the part one, that unit what you have in a block two. So this is again continuation of that. Let's see, the law of sales. Okay, good is an important branch of mercantile law. Okay, the sale of goods is an important branch of mercantile law, and this is so because it touches not merely the commercial but also the economic and social life of the country. Okay, the knowledge of its main principle is of the utmost importance to all classes of the community. Okay, this is very important that everyone should have the knowledge about this Sale of Goods Act. Okay, because it not merely the commercial but also the economic and social life of the country. Okay, so let's see, the Sale of Goods Act attempts to define the position and liability of every manufacturer, dealer, as a seller of goods, and the purchaser. Okay, uh, so it deals with the every manufacturer, dealer, sales, seller of goods, and the purchaser, their positions and their liabilities, what they are liable to, and under the conditions what they have to work. All these things will be comes under this. So let's see, the first one is transfer of title. As I already told you in my previous chapter, about the title. In a sense, title can be best described uh, from the person who possesses it. So there is a rule for that, nemo dat quod non habat. So this is an actually this is in Latin. So excuse my Latin. Okay, so let's see. So there are some exceptions to this rule. Okay, where the transfer of title. So estoppel, sale by mercantile agent. So what is an estoppel? Estoppel, in a sense, where um, Section 27 concludes with the remark that the purchaser may get a good title if the owner of the goods is by his conduct uh, preclude from denying the seller's authority to sell. Okay, whereas, for example, sometimes, for example, a son is selling a product related to his mother, something which belongs to his mother. If a son is selling that, and if in case the mother is keeping quiet and does not interfering or interrupting, okay, in that case, I mean, the purchaser of that goods can claim, I mean later on it's not allowed to the mother that she can change her decision or go against her own decision. In case if they keep quiet, it will be considered as, I mean, they are also involved in the process of the sale of goods. Okay, so that is what it means. That's an example of that. Okay, so they'll be equally binding to the sale. Okay, next one is sale by mercantile agent. Okay, acquires good title if the conditions laid down in section 27 are satisfied. The buyer of goods from a mercantile agent acquires good title if the condition laid down in section 27 are satisfied. So, uh, what are those? Um, so there are many related aspects to that, which I'll be, uh, you know, so let's see. I think maybe it's already. I think the time is. We are running short of time, so I'll try to. Okay, we'll focus on these things tomorrow. So I'll just finish it here. Okay. So sale of goods act or okay. So let's finish it here. So thank you, everyone. I think you have your next class. So otherwise, I would have taken a bit longer time. So the time is very short, and I'm trying to cover as much as possible for you to understand. So let's end it here for today's class. Okay. Thank you.